And this is a program on criminal justice reforms enacted in the 2020 special legislative session. I am going to start off with a disclaimer. When I did this on Martin Luther King Day, the first dozen and a half so of slides are talk about the political atmosphere in which the special session arose. And I was taken to task afterwards by some of the attendees who felt that that was partisan in nature. I'm going to make this disclaimer. It is absolutely partisan in nature, but it's not partisan between the two political parties. It's partisan between what I refer to as interbranch respect. And you'll see what I mean when I talk about that. And I am obviously an adherent to the judicial branch side of that argument. So I hope no one takes offense at what is said here. It is merely meant to give you an introduction to what is going on that led us up to this special session. I've already introduced myself, so I don't need to introduce myself again. As I have mentioned, this is live and interactive. We encourage your comments. You can submit them by chat or by email if you can't access chat, or you can simply unmute and ask to be recognized. If you wish to make extended comments, feel free to do so. I will recognize you. You can unchat. You can even turn on your video if you like. And I will turn the floor over to you, because I know a lot of you out there practice in this area and probably have a lot of opinions about it. So how did we get here? Well, everybody remembers that 2 years ago now, the Democratic Party got back into control of both the State House and the governor's mansion for the first time in 22 years. And there was a lot of pent-up demand for reform issues that the party had put into their platform, had sort of promised people that they were going to do. We all know, for example, restoring felons' rights. That was one of them. Gun control was, of course, a big issue. And another was criminal justice reform. I think I went backwards there. I did. I apologize. So we had the lieutenant governor, obviously, is the party's leader in the Senate, Ellen Fuller Corn, the first female Speaker of the House, and of course, Governor and Dr. Ralph Northam. The legislative agenda in the 2020 long session, which is always the year after an election, is the long session, gave them a lot of time to do some work, and they did get a lot of it done. However, most of that work, as I mentioned, related to the firearms legislation, the restoration of felons' rights, and then also some additional reform to landlord-tenant law, which had already undergone a significant revision in 2019. But the Democrats had to compromise on some issues in order to get the comprehensive overhaul passed. And then when they found themselves in control of the House, they said, well, we don't need to compromise anymore. And by a strange coincidence, we have two upcoming CLEs, one on the revision of the firearms laws, which are undergoing further revision right now. And our presenter has told me that he will make every effort to put, that's not until the end of May. So by then we should know what laws were passed, and he will be updating his outline to include that. And then also the landlord-tenant laws are still undergoing probably some additional revision. I don't know if James Steele and I, who will be presenting that course in March, I think it's in March, might be April. I think it's actually early April. But we will try to give you as much information on that I can. So that is our shameless self-promotion for this particular CLE. Go to the website, sign up. So after they adjourned, it became pretty clear that there was some desire for a special session, something beyond the just the little work that gets done during the veto session. And there were various reasons for this. Mainly, it had to do with two things that I think we could all, you don't need to even guess about this. One was the COVID pandemic. It was really getting underway as the legislature adjourned. It was obviously, we did not know the extent that it was going to reach, that it has reached now, but it was clear it was going to affect the budget, that tax revenues were going to be down, that there were going to be calls on the Treasury for assistance. And it was equally clear to the other side of the aisle. Tommy Norment, the Senate leader, was also calling for a special session because he was concerned about how it would affect business. And in addition to that, there were concerns expressed about the governor's use of his executive power under the State of Emergency Act. Some people felt, and of course this was not just in Virginia, it was in every state, some people felt that the governors were exercising that power a little more extensively than the law necessarily allowed. So one of the things that happened during that time, and this is where it starts to get political, is the governor put off calling the session and until July, and a special session cannot convene until 30 days after it's called. Now that, of course, is an antiquated part of the law that goes back to when you had to get the message out to the delegates by horseback, and then they had to ride by horseback to Williamsburg. But it's still the law. So things were not going to get going until August 18th, which, that's close to 5 months after the legislature went out of session. And this is where I got in trouble because I refer to it as a more controversial move. And a lot of people thought I was criticizing the governor, and maybe I am, but maybe not in the way they thought. He requested the Supreme Court to stop unlawful detainers evictions. And of course, while the courts were closed, none of those cases could go forward anyway. But as soon as they reopened, they were filed, unlawful detainers were filed in record numbers. And there was a great deal of concern that people who, through no fault of their own, had been unable to pay their rent because of COVID, were going to get evicted. And the court did initially grant a 2-week moratorium once courts reopened early in June. Media reports said that Justice Lemons had expressed to the governor his concern that the court should not be involved in making public policy decisions. Nonetheless, because the governor had not called the special legislative session, so there could be no legislation to address this issue. When that 2 weeks expired, the governor sent a message, a letter, directly to all of the chief judges of the circuit, asking them individually to suspend evictions in their circuits. Well, I don't know how much you all know about the importance of seniority and precedence and court systems, but I think you can probably guess that did not sit well with the Chief Justice and the other members of the court. It's just something that really, I think, they felt like it was the governor not respecting the separation of powers. However, the court did extend the moratorium 2 more times. The second time, or the third extension, was by a 4-3 decision, with a fairly unusual circumstance of the Chief Justice, Justice Kelsey, and Justice Mims all actually signing the order. Those of you who get orders from the Supreme Court know they're typically signed by a deputy clerk, or occasionally by Doug Roebelin, the clerk. But to have an actual justice sign an order, particularly a dissent from an order, very unusual. The chief wrote a short dissent. Justice Kelsey wrote a more lengthy one, but the chief's was directed very specifically to this idea that it was not for the court to be addressing issues of public policy. And I thought one of the more salient quotes of that was where he said, this is a direct quote that you see on your screen here: "The court should not create a preference for one set of litigants over another. The judicial branch should not put a heavy thumb on the scales of justice and deny property owners access to the courts and enforcement of their long-established rights under the law." Now, Justice Mims, as I said, signed the majority opinion of the order. But even in that opinion, he said that it was for the express purpose of allowing the governor to work with the General Assembly to provide additional relief to those facing evictions. And I think it became pretty clear at that point that there was not going to be a further extension. Now, I know a lot of you are probably thinking, well, wasn't this being done at the federal level? And yes, we had all kinds of things flying in from everywhere, from HUD and from the Treasury. And I actually was a participant or an observer, I guess you call it, in a CLE, an audience member in a CLE on landlord-tenant law at the height of the COVID crisis back in the early fall. And the presenters there said, quite frankly, it changes from day to day. It's a moving target. So this was all part of a big fight between federal and state power, executive and judicial power. And it really does seem like a lot of it could have been avoided if the special session had been called earlier. But as I said, by the time the special session actually convened in August, this had almost become sort of the tail wagging the dog. The concerns about COVID had started to be addressed at the federal level, and at the same time, we had just lived through the summer of Black Lives Matter movement and the incidents in Minneapolis and Albany and Portland and Seattle and many other places. And the focus of the special session tended to start to be more about these social justice and criminal reform issues. At some point, it was suggested that, well, we had intended to get to this, we just didn't have time. But others said, I think national events have probably made something that was not quite so urgent in January, much more urgent in August. And as I said, I seem to have painted myself into a corner where we're about to turn political. So I'm going to artfully dodge away from that and get into the topic of this, which is those criminal justice reforms enacted in the 2020 special session. I'm going to pause at this time to see. I don't think we've had any comments here. Nobody's threatening to lynch me, so that's good. And I will just very briefly replace the links to the written materials, the reminder about giving us your name and bar number, and also encouraging questions, and we will get back to it. That took me all of about 13 minutes. So I think that's what it took the first time. So there are basically 16 topics. Most of these involved a single piece of legislation. Some were omnibus bills that changed a lot of different code sections. But each addressed sort of a different topic. And so that's how we've broken it out into 16 topics. And the first one is empowering civilian review boards with subpoena and disciplinary authority. Now, the civilian law enforcement review boards go by several different names, and they were always available. A city or a county could create one of these panels, but they were strictly advisory. They had no real teeth. And they were there to offer advice to the police, to the chief of police especially, who was then free, of course, to take that advice and reject it as he saw fit. By the way, I am a little parched, and since we're doing this in the evening, I have my unlike during the daytime when I display an amber liquid and then concede that it is tea, this actually is wine. So feel free to, imbibe if you've got some there. And I thought we'd play a game. If you can spot the typos in the CLE, point them out to me. And I mean, in the PowerPoint, point them out to me, and I'll have to take a sip. So I'm going to take my first sip now, even though there's no typo there. Went my whistle. The General Assembly voted to change that, so allowing local governments to create the panels to field citizen complaints, investigate them, and issue binding disciplinary rulings. Now, we had some very interesting comments on this during the MLK Day presentation. The first was the statute specifically mentions cities and counties. It does not mention towns. And while I don't know for a fact that that was intentional on the part of the legislature, we all know that if it's not there, it ain't there. I'm not going to try the Latin on you, expressio unius or whatever it is. It's whatever, but you know what I mean. The mention of one thing implies the deliberate failure to mention the other. So whether that was intended or not, I don't know. Somebody suggested that it might be subject to correction in this General Assembly to include towns, because town police forces are, you know, certainly no less common than county and city police forces. The other thing is that somebody pointed out is that it is still up to the locality to create the panel. There is no mandate for these panels to be created. And that, so based on some, let me get up to that. I'll go back to that in a minute. Whoops, well, maybe not. I thought somewhere in here I had the notes that said, well, okay. Anyway, I was only able to locate about 4 existing panels on the internet. I was told by some of the participants that there were a few others, not many, mostly in the larger urban jurisdictions. But I then raised the point that if you can't find them on the internet, what good are they to you? If you don't know how to make a complaint to the Civilian Review Board, you know, what possible benefit is it to you? And everybody looks up everything on the internet now. I really thought I had a slide on that. Maybe I passed over it. Oh well. Let me get up to where we were there. So it also exempts sheriff's departments because sheriffs are elected officials, and the legislature, there was discussion of this, and they said they're elected officials. If the people don't like the way they're running their offices, they can vote them out of office. That may very well be true, but it's small solace to the person who has a complaint against a sheriff's deputy. So there was some discussion about whether or not that might be subject to amendment. I do know that the Sheriff's Association was opposed to it and probably still would be. So that brings us to the end of our first topic. At this point, I would like to remind you this is an interactive CLE. So if anybody has any comments or questions, I don't see any coming in. Oh, here's a comment. I don't have access to chat. Okay. Well, that's an interesting comment. But thank you for letting us know that you're here. Okay. How do I get back to the inbox? Let's see here. I'm not sure if the chat feature is operational. Somebody says, please contact me. I'm not sure. Ms. Johnson, if you're online, I'm not sure what it is that seminar tonight. I think I accidentally deleted the link to the Zoom material. Okay, let me very quickly respond to that. I know I said I wouldn't do this, but go to the website and you will. Oh, you're here. Okay. Well, all right, then I won't send this to you. Okay, so I don't see, can you explain how a citizen review board works? Well, that depends very much on the locality because they create and set sort of their own rules. Now, in the legislation, there are some very specific guidelines for the authority that they have, but essentially the way it works is, somebody tried to, what time did you send this? Somebody tried to sign up at 7:04 p.m. You tell her, go to the website to get logged on. Go to the website to get logged on. Okay. And the basic way it works is you have a citizen commission. Sometimes it might include a member of the law enforcement or of the local government as well. Sometimes it's ex officio members. If a citizen complaint is filed, initially, now they actually have subpoena power. They can actually subpoena records and police reports and such things. And if they find that there was some violation of policy, some violation of civil rights, they can now make a binding recommendation or a binding, I guess you call it a punishment almost. Up to, and I suppose including, I don't know this for a fact, but I assume dismissal of the officer. It would be obviously an appealable decision, but nonetheless it would be binding. Yeah. Okay. That seemed to be the only question, but it was a good one. Thank you. And I'm going to repost some information here, make sure it goes to everyone, because I'm bad about sending it just to one person. And we'll move on to topic number 2, and we're 24 minutes in. Oh, here it is. I knew I had a slide on it. So I was only able to find websites for Charlottesville and Fairfax. Virginia Beach has what they call an investigation review panel, and Richmond has a community police review commission. And then I was told that there are a couple of others out there. Roanoke, as far as I know, does not have one. Roanoke County does not have one. Salem does not have one. And I don't know of anywhere else in Southwest Virginia that has one. Hopefully with this legislation, it will become a more common thing.
John, this is John Tyden. Can you hear me?
Yes, sir. You have a comment or question?
Yeah. Who actually is responsible within the government? I live in Arlington, Virginia. Who is responsible within the Arlington County government to establish this panel?
That would be the Board of Supervisors. So the Board of Supervisors is authorized to establish the panel under this legislation. I presume that if they would do it, it would probably be because of a citizen initiative. In other words, I think you're going to see these panels in places where people want them. That would be my guess. Now, I suppose there are, I hope I'm not insulting anybody. If anybody out there is on the Board of Supervisors, I'm not talking about you. I suppose there are some Board of Supervisors members who pay attention to things like this that the General Assembly does and says, hey, that's something I'd like to work on in my community. But my general impression is that the General Assembly ignores what the localities do, and the localities tend to ignore what the General Assembly does.
As an aside, I can't get my chat to work, but my bar number is 9274.
Okay.
That's all the numbers, by the way. Okay. 4 digits.
I'm sorry to tell you that you're not even close to the lowest number we've had on a CLE. We've had somebody whose bar number was 4 digits and started with 1, 2. But thank you for your comment. So one of the things we did discuss, we already talked about the exemption for sheriff's office. And finally, we just talked about civilian oversights. Are they going to curb or encourage civil litigation? And there was a wide gulf between people who thought, if you have an outlet for your complaint and you see that it is taken seriously, you're not gonna go to the expense of filing a 1983 action. And others thought, no, if you have a civilian review board saying that the police violated any policy, even in the smallest event, you're going to see that, or perhaps someone is going to see that as an opportunity to cash in. I tend to think I tend to lean more towards it will curb it. I think a lot of times what people want is a recognition of how they were treated. And if they have a group of citizens telling them, we don't see what the police did was wrong, or we do see what they did was wrong, a lot of times people just want to be listened to. If you have a different view on that, feel free to chime in. But I do think it's, wow, did we just jump like way ahead there? Okay. We'll go ahead and move on. Effective, not, oh yes, take a drink. Yeah, somebody spotted that one in the first one too. And I made no changes. So there are others in there. Okay, yay. Please find them. That way I get to drink more. Moving on to topic number 2, banning police from executing no-knock search warrants. I should mention that on all of these opening slides, you'll see that most of these statutes have not gone into effect yet. Some of them have. Some of them will go into effect in the next several months, if not changed by this session of the legislature. Some will not go into effect even until next year or later. For those, that was because there were administrative things that had to be set up, processes that had to be set up before they could be effectively enforced. So this was I think probably the topic that had the most discussion during our MLK Day presentation. So I will be watching the chat window to see if it generates additional discussion here. Called Breonna's Law after Breonna Taylor, who was shot and killed during a late night raid in Louisville, Kentucky. The legislation makes Virginia just the 3rd state so far, I should say, because other states are considering this legislation as we speak, to bar police from executing warrants without first knocking and announcing themselves. Law enforcement agencies were divided on this, with some arguing that unannounced searches are important in limited circumstances to protect officers and evidence. Others said they didn't use them at all, so it didn't bother them that they were being told they couldn't. So to discuss this topic, no-knock warrants were not commonly used in the U.S. I looked this up until really starting in the 60s. And that was when the Supreme Court first recognized that they could be proper if there were exigent circumstances. In a PBS NewsHour report, it has been suggested that no-knock warrants are a product of the war on drugs, and therefore were much more common after the Nixon and especially the Reagan administration. And the numbers tend to bear that out. So even into the last decades of the 20th century, they were relatively rare, with about only 1,500 a year. Most of those were federal DEA cases, not local cases. But following Hudson versus Michigan in 2006, which held that evidence seized in an illegal forced entry was not subject to suppression, the use of no-knock warrants just went off the rails. 60 to 70,000 a year in the last decade. Mostly they were by local police agencies, and most commonly they were for marijuana. There was very rarely a serious drug operation going on in the location that was being searched. And very often the residents weren't even armed. I just so happened to know that recently in Chesterfield, it was not a no-knock warrant, but it was a knock and push in type warrant. And there were 3 adults and 2 children in the house. There was a quantity of marijuana. There were no guns. It was not a distribution or anything. Issued, not issues. Take a drink. Doug, you got an eye. Thank you. Somebody, it tells me somebody's reading the screen. That's good. I recently put in one of my blog posts. I recently started a blog on the Virginia Court of Appeals, and I found myself in agreement with the affirming of a criminal decision, and I said, Is that because I've, my bleeding heart has suddenly turned to a heart of stone? And so just to get back to the bleeding heart side of it, no-knock warrants for small amounts of marijuana just make no sense to me. I realize it can be flushed. I get it. But the danger that it puts people in. Or are they an effective tool? I don't think so. I think if you have enough evidence to get a no-knock warrant, you probably have enough evidence to go ahead and arrest them. I think they definitely do increase danger to police and occupants, either because the occupants have no idea what's going on, or worse, the occupants know exactly what's going on and they're ready to do what they can to stop it. And then one of the criticisms raised of no-knock warrants is that in states that have stand your ground laws, you have a law that says you have an absolute right to shoot somebody bursting into your house without any legal authority to do so. And a no-knock warrant, until you see the person's vest that says police or sheriff or DEA or whatever, they could be anybody. So I will pause again here momentarily to see if anybody has comment. We had a lot of comments on this. I guess maybe people are more mellow in the evening. Or perhaps they've just spent.
John, this is John Hyden again.
Yes, sir.
I would have thought that you didn't need a stand your ground statute to defend your own home.
Well, that's true. The castle doctrine. So one could argue, by the way, thank you, Lauren. I did take a drink. I don't know if you saw me. But yeah, the castle doctrine is actually well established in this country. I think the concern was that that stand your ground laws perhaps make it more likely that someone would react than just the castle doctrine. So that's a good point, John. Thank you for that. Looks like we did have a very spirited discussion on this that went quite long during our first one, and I felt we needed a little humorous break, so that's what you're getting now. I hope that the sound is turned on for this. I don't know if I shared the sound on that. I hope you did, but that was from the Big Bang Theory. What, somebody heard it? Okay, good. No sound. Oh, somebody said no sound. Well, you know what? I'm going to insist that I'm going to unshare. I'm going to reshare, and I'm going to make sure I turn on the sound. Yeah, that's what I did. I didn't turn on the sound. And then we're just going to replay that.
Knock, knock.
Who's there?
Interrupting physicist.
Interrupting physicist.
Mew on.
You kind of have to know something about physics and knock-knock jokes to appreciate that. The original one is interrupting cow, moo. So, okay, I had fun. I don't know about you. The third topic, downgrading a handful of minor traffic violations to secondary offenses starting March 1st of this year. This was certainly the most widely publicized of the new legislation. It got quite a lot of play in the press, primarily because after it was passed and had been sent to the governor, somebody pointed out that it probably had the unintended effect of not allowing an officer should be aimed at curbing. Was there a typo? Oh, well, okay. Got to take a drink. Who was that? Rhonda. Thank you, Rhonda, for encouraging my my alcohol consumption. I assure you, it's a very low alcohol white Zinfandel. Not that you can tell it from my behavior, I'm sure. That it would have stopped an officer from making as the primary basis for the stop someone driving on a dark road at night with no headlights on. So they did very quickly get that fixed in the veto session. The governor made some changes to it, but still others thought that they had perhaps gone a little bit too far in the very, very many items that were changed from primary to secondary offenses. And what I thought was interesting that we now also have the distracted driving law, which was, of course, enacted in the question. Okay, let me stop and read that. Does this mean that these traffic stops are no longer offenses, or just that they can not only be, no, they are still offenses, but they cannot be the basis for the stop. So if the officer has a legitimate basis for stopping you and you also have a broken taillight, or you have tinted windows, or your muffler is too loud, he can write you for that. Can or did you provide the slight? Yes, it is. Oh, where? There? They're not there. Are there? Oh, you all probably think I put those in there purposely, don't you? Can or you provide the PDF? Yes, let me post that link again right now, along with the link to the written materials, and you can go through the printed material and find all the typos in advance so that you can be ready. Oh, I bet I just sent that just to Doug. Hang on a second. Let me send it to everybody. Okay, so the first link there is for the written materials. The second is for the PowerPoint. So yeah, getting back to that question, these are still offenses, and you still can be cited for them. You just can't be stopped for them. And as we all know, several of these, broken taillight, loud muffler, tinted windows, very common as a pretext to finding out what is really going on. So my question was, now that we have this distracted driving, you know, the suppression hearing, the officer gets on the stand and says, well, Your Honor, I looked to me like he had a cell phone in his hand. And, you know, is the dash cam going to show that? The guy, he went, Your Honor, he went past me. I saw the cell phone in his hand. I hit my lights. I spent 27 years working in a local courthouse in the general district court hallway, next to a general district court judge's office. I have nothing but tremendous respect for police officers, because I have seen far more examples of officers of being honest and sinking their case than I have of being suspicious of officers. But what I'm saying is, it's a pretty subjective standard for the distracted driving. If you've got your hand cupped near your face for any reason, from the outside, it's going to look like you're holding a cell phone, whether you are or not. And I think there are still other ways. I mean, we're still going to have stops for, you know, rolling stop, so-called rolling stop to a stop sign, and crossing the double yellow. And I mean, there's still plenty of primary reasons why the officer is going to stop you. And we all know officers have great instincts. If they think there's a reason to pull somebody over, there probably is. But I still think that it's this bill is, I don't think it's going to solve a problem. If an officer is looking for a pretext to stop you, he's going to find it. She's going to find it. Let me take a quick aside here. There was an interesting opinion came out this week from the Court of Appeals, in which the officer testifying in the suppression hearing used a phrase that I had never heard before, and he referred to it as he was requesting a stop out of a vehicle. And at trial, he had to explain what he meant by that. He said, well, I wanted them to make it a consensual encounter, not a pretextual stop, but I wanted them to somehow make it a consensual encounter. I did a search of the entire national database. That phrase is not something that's commonly used in law enforcement. It doesn't appear in any other opinion. So if you've heard of this, the stop out procedure, let me know about it. I will tell you that it turned out not to be a problem for the Commonwealth, because the officer who was requested to do the stop out did not. He activated his lights and sirens, and so the Commonwealth conceded that it had been a non-consensual stop. Okay, so I don't see any more questions. We'll move on to number 4. We're actually now 43 minutes in, which means we are past the half-hour mark. So I am going to go ahead and post the information about CLE credit. This will be emailed to everyone whose attendance I can verify. It'll probably be late this evening, late tonight, before I can do that. It is a somewhat tedious process of for the 90% of you that are on the Zoom log. It's not tedious. It's the ones who, for some reason, I haven't been able to verify. And we do have 80 out of 112 here, so I'm going to have to eliminate 32, figure out who the 32 are that didn't sign on. But most of you will get a copy of this attached in an email, presuming, of course, you're getting your VMVLA emails. Good. So I'm about to post that now. I want you to look at that number. It is N as in Nancy, I as in India, I as in India, 0363. Okay, so NII 0363, not NLLO, which a lot of people tried and stuff like that. So you can submit it online. Right now you'd be entitled, you can't quite round up to an hour yet, but we're getting there. So you're entitled to half an hour, and shortly you'll be able to round up to an hour. And if you stick with us to the bitter end, an hour and a half, and I hope that you will. This is, we have decided to eliminate the problem of, can you say that one more time? The number is N II 0363, and the link there will take you to the form. Even if you submit online using the number, the bar says you have to have a copy of the form and keep it. Oh, I'm sorry. There, yeah, the password is, and it's there, but let me give it to you. VMVLA, that's in all caps. CLE in lowercase, 127-20021, because I mistyped 2021, exclamation point. VMVLA. In fact, let me just copy that and put it back in the chat. When I email it to you, you won't have to have the password. I'll just attach it. Okay, so don't worry about that. But if you want to download it now, there's the password right there. VMVLA in all caps, CLE in lowercase, 127-20021, exclamation point. I just now noticed that in trying to type the date in numbers, I have put an extra 0 in there. Okay, so let's get back to our presentation. Topic number 4, prohibiting police from initiating searches based on the smell of marijuana. You know, when I first started practicing law, and I was doing a lot of criminal cases, and I would always see the officer saying, well, I immediately detected a strong odor of alcohol. And I thought they were just, that was sort of the script, right? I thought, how could you? And then one time I was actually privy to be at a checkpoint, and the fourth car that pulled up, it nearly knocked me over. I mean, with the windows up, you could smell it. But marijuana is different. You roll down the window and it dissipates very, very quickly. It doesn't hang on to your clothes a lot. And so it was not so much a question of could they actually smell it? It was, well, it's so questionable. I don't know that they're going to legalize marijuana. Of course, we know that simple possession has been reduced to a non-criminal, what do you call it? I'm drawing a blank on it, but not a criminal offense. civil violation, whatever. There's a word for it. I can't think what it is. Somebody will tell me on the chat. But there is talk about infraction. Is that it? Maybe it is. I don't know. About legalizing it entirely. So I'm not sure that this law is going to have much impact going forward. So we didn't really have a lot of questions about that. But one of the issues that I think is interesting is once it's legal, or assuming it becomes legal, are we going to need to revise the laws on DUIM investigations? Are they still going to be valid so long as there's no search of the vehicle? Because all this statute does is prohibit a search of the vehicle for the drug itself. If the officer says, well, the reason I suspected he was impaired was because I could smell alcohol, I could smell marijuana, this law isn't going to affect that. So I don't think it will need a revision of those laws. Topic number 5 is the other one that got a lot to play in the media and has been a very, very active topic among the criminal defense bar, is doing away with the so-called jury penalty of, if you want a jury to determine your guilt or innocence, you have to have a jury determine your sentence. That law is scheduled to go into effect July 1st, and it is based upon the argument juries aren't privy to the sentencing guidelines and aren't able to suspend time, and as a result often hand down sentences far in excess of what a judge would have recommended. I did hear somebody unmute. Was there a comment or question? I'd like to comment on smelling marijuana and how weak that is. Okay, you want to do that in chat or unmute? Go ahead, sir.
I'm here.
Yep.
Can you hear me?
Yeah, we can hear you.
I'm an attorney in Charlottesville, and I live in the country. I have a wood stove. I remember, and at one point I had to talk to the Commonwealth's attorney when I was in court. This is about 10 or 12 years ago, 15 years ago. And he was saying, we were in the lobby of the court. He was talking to a couple of detectives. And then, so I went up and spoke to him. He was, he was a friend of mine, a guy I'd known for years. And then and then I left. And then a couple of days later, I got a call from a mutual friend. And he said, this guy told me to tell John, he said the detectives were all laughing. It's like, he's really not doing his clients any favors, because he really reeked of marijuana when he was talking to us outside of court. Now, that was relayed to me, and I hadn't smoked marijuana in 30 years at that point.
I think it might have been from the wood smoke.
I have a wood stove. I built a wood fire and I went to the assistant Commonwealth's attorney, who was a friend of mine. But before I did, I had a drug test. I got a marijuana test because it stays around for 3 weeks, and I said, I don't expect you to believe me, but here's a test. I've tested negative for marijuana. If I'd smoked marijuana any time in the past 3 weeks, it would show up on this test. I haven't smoked marijuana for 30 years. And yet your detectives were all laughing and joking that they detected the smell of marijuana on me, and I was just reeking of marijuana. So that's how accurate that determination is.
And that's why we now have a law. Thank you for that comment, sir. Moving on to jury sentencing. So unless a defendant specifically requests to be set by a jury, advocates predict that this will force prosecutors into more lenient plea bargains. I don't know that that's true. What I do know is a local attorney contacted me sometime before the first seminar, because I can't remember when. I think it was early January, and asked me whether he thought he could file a motion for a continuance for a trial to past June 30th, because he thought his client would do better with a jury trial but a judge sentencing. And I have not heard from him to find out whether he filed that motion or whether it succeeded. I rather think that if that is your only basis, and he wanted to make an equal protection argument, and I said, well, I don't think that this is an equal protection thing. It's a change in procedure, not a change in the law. And equal protection usually doesn't apply to that. But I would be interested to hear if anybody succeeds in that. And I think the closer we get to that July 1st date, the more likely it is that criminal defense attorneys who want their clients to have the opportunity to either request a jury for the guilt phase, or at least use that as part of their bargaining for the plea agreement, will find suddenly that they have very, very heavy calendars, and will be more than willing to waive the speedy trial date if they can move it past July 1st. The sixth topic, creating Virginia's first statewide code of conduct for police officers. I know a few local politicians who thought that this was Richmond meddling in their affairs. I know quite a few state lawmakers who thought that it was not something proper for the state to be doing. But nonetheless, it is there. The law enforcement conduct is governed by the rules and regulations adopted by individual officers around the state, and they can widely vary. And I think that the belief here was that uniformity was preferable to a lot of instances where topics simply weren't being covered in some of the police manuals, and that it would take practically a change of administration at the top to get a new policy adopted. There were some police agencies that favored this, even if their local boards did not. There was one issue that the police chiefs had brought up with the legislature, which I had heard about, which is officers being allowed to resign rather than face discipline, and so not having a disciplinary record and being able to go literally to the next county, the next town, and be hired there. So it now requires departments to notify the state of serious breaches triggering a state-level decertification, which is currently limited to circumstances in which an officer has been found guilty of a crime. So this takes that away and makes certain procedural breaches also. Someone asked a question in the MLK Day presentation of this CLA. Does that cross state lines? And I simply don't know the answer to that. I don't know if there is some type of full faith and credit, but my guess is not. My guess is that being decertified in Virginia, they can simply go to, will notifications to the state and or decertification matter be a public record disclosure? Yes, that is, there is a database that is publicly accessible. Until that happens, though, it is considered a personnel matter and would not be public. You know, we just had the two officers in Rocky Mount who were fired after first being put on administrative leave after they were found to have participated in the January 6th demonstration and assault on the Capitol, and have actually been charged with federal misdemeanor crimes. The statement that was issued by Rocky Mount about that, I represent police officers against misconduct claim. It is not so easy to move from one agency to another if you've been subject to discipline. Again, I have heard of cases where that happened, but I'm not suggesting that it is common and every day. I think the issue that was being raised during the special session was where before they were subject to discipline, they were being allowed to voluntarily resign so that there was no record of it. Whereas this now requires, once the complaint has been made, there has to be a resolution and a report of that. At least that is my understanding of it. But thank you for that comment. those Rocky Mount officers, the statement from Rocky Mount acknowledged that within the community there was a tremendous sort of backlash against the police department and the town council, because these officers were only put on administrative leave. And so in that statement, they said, look, there's a process we have to go through. We can't just fire somebody from the police department. There's a process we have to go through, and it has to be private. And then went on to say that they moved much more expeditiously than in a normal case, which I think we can all agree, because it all happened within the space of 3 weeks, which is very fast for these types of proceedings. And of course, the one of the officers, the older of the two, who was given the chance to retire, but said that he was going to fight it. So I'm sure we'll be seeing a lot more about that in the paper. One criticism of the bill, and the next three to be discussed, is that they divest local control, as I mentioned. And of course, this is a good time to remind us all that we are a Dillon rule state. So internal management of local officials, while it's traditionally been left to the local government, is a matter that can be controlled by the state. If the state does not delegate it to the locality, but wishes to direct it from Richmond, some would say micromanagement from Richmond, they can do so. That's the essence of the Dillon rule, that these localities only have the authority that the state specifically delegate to them. The seventh topic, let's see, we are now at the hour mark, so you are entitled to an hour if you have to get off and handle your regular evening chores. Thank you for coming. I hope you'll stay. We will get through, even though we're still going slow. We're much faster than we weren't up to 7 at the hour mark, and these next ones move through fairly quickly. This one mandates racial bias, de-escalation, and crisis intervention training. It is one of the ones that was a lot of local governments were criticizing it because it's mandating additional training for their officers without providing any funding. I can appreciate that, but that's what the that's what the legislature likes to do. There was a companion bill that expands the memberships of the committee that will create the new standards to include representatives from minority, social justice, and mental health organizations. Many experts question the effectiveness of anti-bias training, and during our MLK Day presentation of this, we did have some very interesting comments from people who said that their experience had been that it was actually more effective in giving those who have implicit biases. We've got a long comment here, which I'll look at shortly. But they said it basically helped those who have implicit biases figure out ways to make it look like they weren't biased. That those of us who have subconscious biases can be helped by this training to recognize them and avoid them. But for people who have a deep-seated racial or gender or ethnic bias, that it's very difficult to retrain that way of thinking, and that the training was actually giving the officers sort of clues. Well, now you don't want to do this because then that'll make, oh, well, then I'll find another way to get the guy without doing that. Let's read this comment here. I worked in Oklahoma courts for several years. It was permissible to use the deferred sentence in most cases. The sentence could be deferred up to 2 years. The defendant could be required to serve time in the local jail, do weekend service, community service. After 2 years, the defendants could withdraw their appeal and the case would be dismissed. This process could only be used once. I had a classmate who stole, I'm guessing a car maybe, prior to graduating from high school. He served the summer jail, attended college, and went to law school. He's now retired. What would it take to get Virginia to do this? Simply putting young men and women in jail is stupid. We do have diversion programs. I mean, there are some out there. They're usually specifically tailored to individual crimes. So we don't have like a general blanket policy for diversion. The criminal justice reforms that were enacted during the special session were very much directed toward police activity as opposed to broader social justice, criminal justice reforms. I think that we will continue to see movement in that area, just as we've seen some loosening of Virginia's. I had an interesting discussion once today with somebody about, does Virginia still have a parole system? Yes, we do. We have a parole board. We have geriatric release and all of that. But mainly, we don't have parole. We don't have a meaningful path to release for adults. We now have special legislation for juvenile. Diversion programs are something akin to that, giving people a meaningful opportunity to avoid the repercussions of a serious criminal offense. And depending on the how the political atmosphere moves in this country over the next several years, you may see more of that. You may see the pendulum swinging back. I know a lot of people that feel like it's gone too far already. But that's a very good comment. Thank you. The next one is creating mental health crisis response teams to co-respond with police. This is one that is going to require some implementation. There are going to be several regions around the Commonwealth that will have these teams in place, but obviously they're going to be more beneficial in urban areas where they'll be able to get to the situation than in some of the rural areas where they might be several hours away. So depending on whether we're talking about a short-term crisis or some type of a standoff situation where these specially trained individuals can get there, they may or may not be beneficial. This was one that some police officers did feel like it would be more dangerous because they don't want there to be a division of authority between police and the crisis intervention team. If you've got the SWAT team leader thinks there's an endangered person in there, we have to go in, and you've got the crisis team leader saying we need more time to convince this person that they're safe and that they can come out. They wanted there to be a clear dividing line, and I don't think they feel that the legislation gave them that. So as I mentioned, there are 5 regional teams. They're supposed to be in place by the end of this year. They will have specially trained people. I did a little research to find out there are units like this already in some local police departments. They're just not, they're governed locally. There are other states that have implemented this with mostly good results. When you have highly qualified people who are experienced with dealing with those who are mentally ill, those who may be facing some type of a life crisis, that they can offer a perspective that the police don't have. But there were others who felt that, as I mentioned, it would put them at risk because of the division of apparent control. Who's really going to be in charge here? Is it the police officer, or is it the head of the intervention unit? Number 9, limiting when police can use chokeholds and requiring officers to intervene in excessive force, going into effect in March. The legislation says police can only use neck restraints when they are immediately necessary to protect the law enforcement officer or another person. We, of course, all know that this legislation almost certainly came about as a result of the incidents that occurred in Minneapolis. If violation of the law would subject them to administrative decertification, the impact that it will have on the practice is subject to ongoing debate. There was some concern expressed about the require. Okay, let me see. We got another question here. Are you aware of law enforcement personnel going back from mental health training dually trained? This seems like it would be good area for such. I do know, for example, I know of a local program here where officers get special training in dealing with developmentally disabled people, and they have special training for that. The crisis intervention team, though, would not be a law enforcement body. They have no law enforcement power. They are counselors and experts in things like de-escalating domestic situations and things like that. So I suppose what the suggestion here is that would address the officer's concern about the chain of command. If you had, in other words, if you had officers who were trained in crisis intervention, and as I say, I know of local programs that do that. I'm sure there are many others. But I think the feeling is that the specialized training that an officer get is not a substitution for someone who is a true professional in the area. But that's a very good point. Thank you. The related bill requires officers to intervene if they see a colleague engaged in what they believe to be unlawful or excessive force, and also subjects them to disciplinary procedures if they don't. There were some interesting comments made by individual legislators. Delegate Foy wanted a total ban and criminal violations. She just said there's never a time when that type of restraint is truly necessary. And she was saying, we now have tasers, we have other types of ways to restrain someone. And chokeholds, she said, they belong, I believe the quote was, they belong in the 19th century or something like that. On the other hand, Senator Survell thought that this was probably going to subject police officers to criminal prosecution under the strangulation statute. And he felt so even within the Democratic caucus, there was some division over that. We are well past the halfway mark, but we have reached our interlude. So now that we know that the sound is working,
let's all go to the lobby to get ourselves a treat.
Yeah, the song went okay. I was a little flat tonight.
My grandfather will disown me after that performance.
St. Ma, I'm telling you, not tonight. I don't want any more conditions.
Then he called me and I said, no way, mister.
I'm telling you, Soda always kicks me when she high steps.
Guys, can you just pipe down? The film's about to start.
Oh, really?
Yeah.
Hey, John, this is John again.
Sorry,
was this break noticed in the plan or whatever you want to call it? Because I just took an unauthorized break because my bladder couldn't stand it anymore.
No, it wasn't listed in the outline.
That's something you do.
And I should mention that on Zoom call, when I do live CLEs, I usually the first CLE I ever did, and it's been 27 years ago. At the end of it, somebody came up to me and they said, "You were the first presenter, and you failed to do something very important as the first presenter." And I said, "Oh my gosh, what did I do?" They said, "You didn't tell us where the bathrooms were." So on Zoom CLEs, I presume you know where your own bathrooms are, and you are free to get up and go anytime you need to. And that being the case, and since we are into only 19 minutes left, and I do want to keep us on schedule, we're going to go ahead and skip the break. Feel free to get up and get a drink, or if like me, you have yours handy, take a sip. And we'll move on. So the next one gave inmates some chance to earn early release dates through good behavior and performing, doing some education, participating in counseling, that sort of thing. I have mentioned, I sort of alluded to this earlier, that we are seeing some cracks in the 1995 change in the law that effectively eliminated parole. And it's kind of interesting when you think about it. 1995 was not that long ago. It was, what is that, 27 years. So in the span of just a little over the typical period of a generation, which is usually considered 20 or 25 years, we've gone from wide public support for truth in sentencing, do away with parole. If you can't do the time, don't do the crime, to a scaling back. We have not, by any stretch of the imagination, returned to the catch and release programs of the 1980s and 90s. But we are starting to recognize that incarcerating people for 20 or 30 years when they're very young, or when they're not, and then releasing them in their 40s, in their 50s, sometimes in their 60s, how realistically are they going to become productive members of society? And if they have incentives that will allow them to be released early and improve their chances at becoming productive members of society, that's actually beneficial to us in multiple ways, including reducing the cost of housing them, or warehousing them, as some people would say. I'm probably being a lot more liberal tonight. Maybe it's the wine. I don't recall that I was quite so vocal on this. So again, if you have a different viewpoint, chime in. This is not a what Kohler thinks. It's what everybody thinks. I'm going to go ahead and very quickly repost that link to the CLE form in case anybody missed it the first time. Again, you will be getting an email sometime this evening with this form attached if you don't feel like you need to download it now. If you don't get that email, if you can hear my voice and you don't get an email from the VMVLA by tomorrow morning saying, yes, we have confirmed, yes, we have confirmed your attendance, please contact VMVLA. Or if you think you're not getting through on the VMVLA address, contact me at that JSKohler@gmail. Our number one goal is to make sure that you get the CLE credit you're entitled to. We're a nonprofit. We're about making CLE available and affordable, initially to the Mountain Valley region, but since we've gone digital to the great wide world. Comment saying the abolish parole thing was a complete political pandering measure by George Allen. I'm just going to leave that where it is. I get into enough trouble as it is. Thank you very much. At the time of the bill, they thought it might move up the release of 14,000 inmates. I don't know what the current numbers are. I know the last time I knew, the cost of incarcerating one person for 1 year in the Department of Corrections was $26,000. And that was quite some time ago. So I'm sure it's gone up since then. So just take that 26,000 as a benchmark and multiply it by 14,000, and you begin to see very quickly that you're probably talking about somewhere in the vicinity of what is that, $500 million, or at least 50, maybe it's 50 million. But somebody do the math and let us know on that. It was controversial. It passed on a party line vote. And the patrons actually had to include a long list of exclusions of various violent crimes that would not be eligible for this treatment. Yeah, twice what somebody says, twice what VA spends per pupil in public schools. It's a lot more than twice. I'm pretty sure at least around here in Roanoke County, I think we spend about 8,000 per pupil. And I know up in Northern Virginia, it's more because they have a bigger tax base, but I prefer living in the beautiful mountains. We have good schools. And also there was a delay in the enactment because they said this is something that we're just not set up for in our computer record keeping system. We also expanded compassionate release. This is not a separate section, but just mentioning it. It allows the parole board to consider releasing terminally ill inmates whose doctors expect to die within 12 months. Like the earned sentence credit bill, the measure excludes most violent felonies. What are we on now? 11, imposing modest limits on military equipment available to law enforcement. Of course, this is a topic that has gotten a lot of national attention with the militarization of the police. The language included in an omnibus reform bill passed by the Senate blocks departments from requiring certain military equipment, including weaponized drones, combat aircraft, grenades and grenade launchers, mine-resistant armored vehicles, bayonets, tanks, and 50 caliber or higher weapons. I was astounded when I read that. Grenades and grenade launchers. We're not talking smoke grenades, by the way. Okay. Tanks. Yeah, that's wow. There was some controversy about the mine-resistant vehicles, which departments said that they use for standoff situations, rescues. There is departments can apply for exemptions to any of those, but particularly the mine-resistant vehicles. But I guess even if they want grenade launchers, they can apply for an exemption to that. If the department's, well, I just said that, didn't I? Get ahead of myself. I think recent events at the nation's capital suggest the legislation may need to be reconsidered. I don't think it will. We'll suddenly see a lot of jet aircrafts and weaponized drones in our police departments. But for example, having some of the heavier equipment to use in crowd control and that sort of thing. I do think what will happen though is they'll just probably see more applications for waiver. I don't think they'll actually change the law. Again, feel free to comment at any time. The police department had a tank around during the Detroit riots. You know, I know some military people who said just the presence of a tank can calm down a situation, that people are just very intimidated by it. But to me, if you talk about the police using a tank during a riot, I think of Tiananmen Square. You know, that's my image of a tank being used to quell a riot, is that one man standing in front of a tank. So affirming that local prosecutors have the authority to dismiss whatever cases they want. If you are like me, you thought they could already do that. And in fact, they can. They could. This law was merely clarifying that the authority to dismiss or not bring to null pros cases rests entirely with the elected Commonwealth's attorney, not the judge. And this was, of course, because in several localities where there were newly elected prosecutors saying, well, I'm not going to bring any more marijuana charges. I'm not going to bring any more 0.08 DUIs with no damage or injury, no children in the car. Just, you know, I'm just not going to do it. Or I'm not going to send prosecutors in to do traffic tickets anymore. And if the police officer doesn't show up, they will just null process. And the judges are saying, no, you can't do that. So this was not so much a change in the law as it was an admonition to those judges who were stepping outside the boundaries of that. A lot of you probably remember when Moreau was decided, the Supreme Court declined to rule whether there's inherent authority for the trial court to defer or dismiss a criminal case. And it's possible that those who opposed the Moreau decision, and it was very strongly opposed for a couple of years in a row, judges went down for their reappointment interviews and they were all asked whether or not they would follow the rule of Moreau, which wasn't actually a rule. The court said, we're not going to rule on it. But effectively, Moreau allowing them to defer or dismiss. And the question is now, will the opponents of Moreau say, well, clearly this, now that it's written into legislation, clearly it rests only with the prosecutor. That's not what the law says. It doesn't say the court can't do it. It says the prosecutor can. And I still very strongly believe in the inherent authority of the courts to do mercy. I'll tell you a very quick story, and we're down to just 8 minutes, so I'll try and make this as quick as I can. One of those judges who went in to was interviewed and asked about his opinion on Moreau versus Fuller. Very, very good friend of mine, and he looked at the panel, and he said, "Well, I'll tell you," he says, "I very rarely take cases under advisement if I've made a determination of guilt. I just go ahead and convict." But he said, "I had one case recently where it was a veteran. He was being charged with possession of marijuana. There was no question of his guilt, but he was using the marijuana on advice of his VA physician at the Salem VA hospital for his testicular cancer. And the doctor came in and testified for him. And I said, Doctor, what's his prognosis?" And he said, "Well, I seriously doubt he's going to live more than 3 months, 6 months at the outside." And I decided to take that case under advisement for 12 months. He said the chairman looked at him and said, "Well, I guess that was a good idea." So even those who were necessarily opposed to the Moreau decision were, okay, there are times when a judge can show mercy. Number 13, making it a hate crime to make false 911 calls motivated by race or other bias. Of course, this is called swatting for those of you who are not familiar with it. Swatting is already illegal under both state and federal law. It's a misuse of the telecommunications system. This simply creates an enhanced penalty for where there's evidence that it was done specifically for to motivate based on race, gender, religion, disability, that sort of thing. It was called the Karen Act when it was adopted in San Francisco, and that was they were trying to name it after the Karens, right? So they called it the Caution Against Racially Exploitative Non-Emergencies. They couldn't come up with a K word to spell Karen, so they had to use a C word. I don't know that it was particularly directed so much at the Karens as it was of the people who use it to harass their neighbors and that sort of thing, because they're just mad that they're living in the neighborhood. I mentioned it is a federal crime in some instances, in fact, most instances really, because it's an abuse of the telecommunications system. However, the evidence is that most swattings are motivated by the desire to harass or prank the victim. It's not a racially motivated thing. It's usually often the ones that bother me most are the ones that are just random, Number 14, authorizing the Attorney General to investigate local departments. Again, this was one that I thought sort of already existed, but Senator Lucas felt that it needed to be spelled out that there was an express authority to do this, owing to some incidents that had happened in her district. And so it specifically authorizes the Attorney General to initiate a civil suit or to seek reconciliation through the Division of Human Rights, any unlawful pattern or practice against the Commonwealth or locality when the Attorney General has reasonable cause to believe law enforcement officers of any agency of the Commonwealth, I guess I should say, are involved in an insidious pattern of racial discrimination. Probably got truncated there. So we got 4 minutes left. Some have expressed doubt about the Attorney General, whether the Attorney General will exercise the power, preferring to leave internal policies to law enforcement. I think that will depend on how much pressure is brought to bear on the Attorney General in a particular case. After the look, I get to take another drink because we used a slide and we didn't change it. See, it's got the wrong thing down there at the bottom. It's got number 4 and we're actually on number 15. So I get to take another drink. After the COVID outbreak in the Farmville Detention Center, I think clearly the state felt that they should have the authority to go in and investigate the quality inside these federal facilities. I will tell you that the federal government, at least under the prior administration, said, yeah, well, you've got your law now, enforce it. I don't know if the current administration is going to feel differently about that. So that was put up That's what I just said. The administration change makes this more or less likely. The legislation, which won unanimous support, makes Virginia one of at least a dozen states to pass tightening laws. This is another one that surprised me. Against officers having sex with detainees. I had no idea that that wasn't against the law in Virginia. It turns out that it was against some internal departmental policies. Somebody commented during the MLK Day presentation of this that how could sex with somebody who was being detained by the police ever be consensual? But it is now officially a crime in Virginia for a police officer to have any type of sexual relations with a detainee, whether consensual or not. 35 states at the time have had no such law. Several states have even declined to adopt such laws, saying that they encourage false reports. My response to that is, well, that's why we have body cams. You know, they're there to protect the police as much as they are the public. And
that's all, folks.
Right on time.